Here's a secret most inventors don't know. Your patent is only as strong as its patent claims. You might describe your invention perfectly, but if your claims and embodiments don't match up, your patent may be worthless. In this video, I'll explain the difference between a patent claim and an invention embodiment and why it matters more than you think. Every patent application has different parts. Two of the most important are the claims and the embodiments. They sound similar, but they serve different purposes. Let's break it down in plain English. What is a patent claim? A claim defines the legal boundary of your invention in your patent. Think of it like the property line around your house. If someone comes inside that property line, they're a trespasser. If they're outside of it, they're free to do whatever they like. And it's similar with patent claims. If someone comes within the bounds of your patent claim, then they're an infringer. And if they're outside of your patent claim, then not an infringer. That's why strong patent claims are critical. What is an invention embodiment? An embodiment, on the other hand, is an example or version of your invention that you describe in your patent application. It is necessary in any patent application to provide enough detail so that someone in the field can produce the product or invention without too much experimentation. This is known as an enabling disclosure. So you need to provide a workable example, but you don't want that example to be limiting of your patent. Done correctly, the example shows how your invention can be built or used, but it doesn't limit the scope of protection to just that version. Think of it like blueprints for the same house. You could have one with a flat roof, one with a pitched roof, and one with solar panels. They're all embodiments of the same invention. How claims and embodiments work together. Claims draw the boundaries for protection. Embodiments provide the detailed support that makes those claims credible and enforceable. The Patent Office expects you to provide embodiments so that others can understand and replicate your invention. Without them, your claims might not hold up. Here's the mistake inventors make. They describe just one embodiment, one version of the invention, and then write narrow claims to match. That leaves the door wide open for competitors. Competitors can make a tiny tweak, step outside of your claim, and legally copy your idea. The strongest strategy is to draft broader claims, and then back them up with multiple embodiments, multiple examples, so no one can design around you easily. Here's the bonus most inventors don't realize. You could actually use embodiments to cover versions of your invention that you didn't think of at first. This is done by describing multiple variations of your invention in your application. You cover more ground, even versions you might not build right away. That way your claims are harder to design around. By including multiple versions in your application, you give yourself broader protection. This is how big companies create strong patents that block out competitors, not by accident, but by design. Have you ever looked at a patent and thought that the claims were confusing? Drop a comment below. I'd love to hear your questions, and I may use them in a future video. If you're preparing or reviewing a patent application, don't leave protection up to chance. Click the link below and book your free strategy call with me. We can discuss working together to make sure your claims and embodiments actually work together to protect your invention. In the next video you'll watch, I'll answer the top 10 provisional questions that inventors ask. It's packed with answers you'll need before filing your first patent. Click here, and I'll see you there.